The Employment Rights Act 2025 has lots of changes both to harassment and to equality matters. In particular, the things relating to harassment could significantly increase the liability of employers when it comes to how their employees are treated, not only by co-workers, but also by third parties, such as contractors, customers, and members of the public. So employers really need to have a think about what to do to protect themselves in relation to that. The Employment Rights Act 2025 strengthens protections against harassment and discrimination in the workplace and introduces new employer obligations to promote gender equality. First, employers must take all reasonable steps to prevent sexual harassment of employees, strengthening the existing duty to take reasonable steps under the Equality Act 2010. Secondly, and perhaps most significantly, employers must not permit third parties, such as customers, clients or suppliers, to harass employees, and will be liable if they fail to take all reasonable steps to prevent such harassment. Thirdly, disclosures about sexual harassment, whether past, present or likely future incidents, now qualify for whistleblower protection. At first glance, this may seem unnecessary given that workers are already protected from victimisation, but it does allow for those making protected disclosures to apply for interim relief if they're dismissed because they blew the whistle. If successful, this would mean that they're entitled to continue to be paid throughout the period leading to the tribunal hearing. Another new provision that has been introduced by this part of the Act is that contractual provisions, such as non-disclosure agreements, are void if they prevent workers from making allegations of or disclosing information about harassment or discrimination, or about an employer's response to such matters. This applies to harassment or discrimination by an employer or another worker, and where the victim is the worker themselves or another worker of the same employer. We may see some regulations that contain exceptions to this rule, but we don't yet know the details about them. And finally, the Act has also introduced provisions whereby larger employers, those with 250 or more employees, and certain public authorities will need to develop and publish equality action plans showing the steps that they're taking on gender equality matters, and to publish prescribed information relating to the plan. This will include matters such as addressing the gender pay gap and supporting employees going through the menopause. For more details, please head to our website mishcon.com and look for the Employment Rights Act Hub. There you'll see more information regarding the content of the Act, when different parts of the Act are coming into force, and what still needs to be decided. You'll also be able to download guides as to what employers should be doing to prepare for the changes and what training we have available for your managers and HR teams.